legal right to the note in the beginning. Yeah. But now that they're taking the house back, they forsook that legal right. They must give the note back. So if you lose in the foreclosure is not consummated until you get the note back. Do we all understand that? The foreclosure is not complete. In law, we'll use the word perfected. Hold on for just a minute. We use the word perfected in law. Things are not perfected until everything's been met. There was no foreclosure. It was not perfected. It was not complete until you received the note back. Do you all understand that? If you were foreclosed on and you do not have that note back, you were never foreclosed on. You thought you were, but you do everything wrong because you think it's right. I know you. I've seen you do it. Just like when you thought the deed of trust had something to do with the house, so you made payments and you never got the loan. You never got the loan. You made the payments because you thought you got the loan. You were wrong. Yes?
I must have missed something. Would you please explain what it means legally without recourse? What does that mean? Why don't they want that on the check?
Oh, I took my neighbors are like, I don't know, John, that seems a little. I'm like, oh, cool. Because it was her account. See, I can't have a bank account. I am pretty much persona non grata anywhere. But so I had to use her bank account. So we go there, and I had to endorse it, and then she had to endorse it to her account. And so under my name, and this poor girl, and she was friends with the teller, and it was like, okay, you want to learn this lesson? You will. Words that may be used by a drawer in signing a draft or check so as to eliminate completely the drawer's secondary liability. That means they can't come back at the person. In other words, if your check said, so you got a payroll check. Most people do that electronically, but there was a time when your employer gave you a check and you had to go cash it. And a lot of times, I remember when I was younger, you could go to the grocery store with a payroll check, buy your groceries, and get the difference back. Does anybody remember that? Yeah. Now what I do is I recycle checks. All I'm ever is a holder. I'm never a holder in due course with anything. So I'm a holder. So if you give me a check, and that check made out to me, and I take that check, and I sign it over to the cable company, account number, blah, 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 and they cash that check, was I ever a holder in due course of that check? No, I was a holder. Was that money ever given to me? Is it taxable income? Talk to your accountant. That's fun. I don't hold anything. Nobody ever gives me anything. I just flow through. Just everything. In law, verbiage is everything. Remember, words are fiction. Law is fiction. When fiction is operating in fiction, everything is right. You try to bring truth into fiction, you're going to sound ignorant. You try to bring fiction into truth. You ever have a discussion with somebody and they quote some bullshit statistic like, 95% of all statistics were just made up 5 minutes ago? When you're in truth and somebody brings in fiction or something they made up, you just, I'm to the point now where I'm just like, okay, if you're going to lie to me, the conversation's over with. Just, most people continue to argue. Arguing's like, wrestling with a greased pig. You're just going to get dirty, and you figure out after a while the pig liked it. So I just, you got to really look at fiction and truth being as separate entities, and you don't mix them. Court's all fiction. Words are fiction. Use the correct fiction in the fiction. Keep the truth and reality out of it. I've come to the sincere belief that most people are borderline schizophrenic in their concepts because they can't separate the fiction from the reality anymore. They can't. sports. I absolutely hate sports. I hate everything about it, don't want nothing to do with it. I think it destroys family. I think it's anti-Christian. I think it's the most disgusting thing towards God, because I'd never try to make anybody lose. Sports is about being better than somebody else. My job on this planet is to make you better. If I got to defeat you, I'm already friggin' wrong. I hate this shit. And I think it's so Americanized that it's caused schizophrenia in most of our population. And you see people that are so involved with sports that really, they actually call their football team, their basketball team, that's our team. Oh yeah, you getting a check? Because if you are, lend me some money, I'm broke. You know, it's not your team. And we've become so schizophrenic because we mix fiction and reality so much, and court will not let you get away with it. Without recourse is legal terminology. It goes right into court, and it's very powerful. So if we understand the importance of that, I'm going to jump to one of the newest discoveries. It's in Daryl's letter. It's on page 6. Please go to page 6. Okay, here's what happened. Lauren contacted Cindy. Where are you, Lauren? You're right here. Okay, Lauren contacted Cindy. Needed Cindy to do some affidavit stuff on the chain of title. So, you know, a lot of times you can read something 1,000 times. If you aren't ready to catch it, you just blow it off. But Lauren read his deed of trust, and he's like, Cindy, you know, I just have this question. Why the hell is the deed of trust notarized on a day other than the date of the deed of trust? And Cindy was like, well, it seems like that would invalidate it. So Cindy asked me, I'm like, yeah, of course it's invalidated. Okay, when we look at the deed of trust and the promissory note, I'm just going to throw out a couple of random dates so you understand the explanation. The deed of trust and the promissory note, 2 separate documents. We'll say this is a deed of trust, this is a promissory note. Now we know under Carpenter v. Longan, 1871, that if they're ever separate, that's it. Deed of trust is gone and invalid, that's it. So, they both say October 3rd, 2006. Yet they were notarized, the deed of trust. Normally the promissory note does not get notarized. Okay? But the deed of trust is notarized October 5th. How many people, when they went to sign their deed of trust, had a notary present? Okay, far under half. I would say those are higher numbers than normal, because probably 3/4 of the people that I deal with on a regular basis, there was no notary present. Instead, the title company took their driver's license and made a copy. Why? Here's why. So they can put all that paperwork together, and a notary sits at her desk. In Arizona, a notary can only charge $2. And notary sits there and just signs off. Notary is no good unless you're there. There is that acknowledgement thing. We were talking about it earlier today, and we keep going over that. Listen, an acknowledgement in a notary means you didn't sign it in front of the notary. You came back later and said, yeah, I'm the guy that signed it. Here's my license. That really is my signature. Okay, you got to be there. So they take a picture of your driver's license, put everything together, notary signs it later. That's a crime. Okay? You can't do that. Now, here's the issue when you look at the deed of trust. Normally, paragraph F, if MERS is involved, paragraph E, if MERS isn't involved, 62 million of the deeds of trust is involved with MERS, blah, blah, blah. So just paragraph F. That little funky thing on page 6 right before the sentence starts, that means paragraph. Note means the promissory notes signed by borrower and dated October 3rd, 26. There's 2 elements there. You must sign the note on the 3rd, and it must be dated the 3rd. Do you understand? When you have elements, the both must have to be met, If only one is met, it's no good. Do we all understand that? Okay, so if it's notarized on the 5th, and the bank claims, therefore, that you signed it on the 5th, did you meet the element of the requirement that you signed it on the 3rd? No. No, you did not. Is that deed of trust therefore invalid? Because a deed of trust without a promissory note is invalid, and if they're saying it has to do with the note that was signed on the 3rd, yet they're saying that note was signed on the 5th, what the hell note are they talking about? Which lie are they going to tell now? That law is called perjury by inconsistent statements. In Arizona, it's ARS 13-2705. You can look it up in your own statutes, perjury by inconsistent statements. So if they're claiming that the note means the note signed and dated on such and such a date, that note better have that date on it, and you better have signed it that date, or that note has nothing to do with that deed of trust. And if that deed of trust doesn't have a note, what is it? Yes, yes. Paragraph F, or E if you don't have MERS, and probably 3/4 or more of the deeds, probably more than that, probably 90% of the deeds of trust out there says, note means the promissory note signed by borrower and dated, and then it'll give a date, in this case, October 3rd. So if the bank says you didn't sign it on that date, aren't they admitting that note has nothing to do with the deed of trust? Yes. Or if the promissory note said October 5th, would that promissory note have anything to do with the deed of trust? No. No. Has to have both. So if they're saying on the deed of trust, since you don't date the deed of trust, it's on page 1 and it's on page 2, but you don't write in the date of the deed of trust. So which lie are they telling? If it's notarized October 5th, are they saying that the notary committed fraud, or that you did sign on October 5th, which means the promissory note is not attached to that deed of trust? Which lie do we want them to say? I don't friggin' care. Either way, they're done. They can't win that argument, so the judge isn't going to want you to have that argument.
Yeah, when it means they are done, what will happen after that? If it's proven in, okay, that was wrong, what is the next step? Is the whole deal is rewind and...
It didn't exist. In law, it didn't exist. That deed of trust does not exist in law.
I got it. Practically after that, what does it mean? Is we ask for the money, give back us the money, bank, here is the...
You tell the bank to walk away, and if you had an honest judge, the judge would tell the bank to walk away, and all the money that you've been paying is in a deposit account. They need to issue you that money back.
And what happens with the title?
I can't hear you.
And after what happens, who will be on the title of the property? Will that be given back to the original seller?
Sure, they'd have to reconvey the deed and all that.
Okay.
Absolutely.
The other thing, you made the reference, if the trust and the promissory note ever separated, was a law case in 1871. Could you please?
Carpenter v. Longen. Carpenter v. Longen. If you're not familiar with that case, you've already got a problem, okay? Yes.
Just real quick, you alluded to the fact that they take your driver's license and then they give it to a notary potentially afterwards, hypothetically,
yes,
in some cases. Then how do they get away with the fact that you have to put a finger stamp or a thumb stamp on the notary's book?
Okay, I get stuff notarized constantly. I'm involved in so much court stuff. I don't ever give a very rarely do most people give a thumbprint or a fingerprint when they notarize. Very rarely. It is happening now, probably more than it used to, but very rarely. What?
California's required by law.
Is it really? In Arizona law, it's not. It's and the notary books have a place there. I don't give it. See that's you have to be familiar with what's going on in your state. That the way Arizona is written, if you request the notary pages, they got to give it to you. So if you're this deep into it, you should request the pages from the notary's book in all matters to do with your case.